The Industrial Dispute Act 1947, presented by Ms. Anita Parmar. Whenever we start with any act, remember you have to always understand the object of the act. Why was the act brought in place? Why was it enacted? What was the reason for the government of that time to create this act? Right. So first we understand who are the participants in this act. They are the employers, the employees, and the workmen. The object of the Industrial Disputes Act is to make provisions for the investigation and settlement of industrial disputes. The Act lays out what type of interactions will be defined as industrial disputes, because once any dispute is defined as industrial dispute, then the employer, the employees, the plaintiffs, the applicants have the right to go to separate courts created under the Industrial Dispute Act. They don't have to go to the civil or criminal courts. Right? The purpose being the Industrial Dispute Act wants to ensure that social justice is brought for the employers and the employees. It also provides for collective bargaining. Why? Because there are no strikes or lockouts. There are no layoffs and retrenchment which are illegal. The Industrial Dispute Act 1947 clearly defines when is a dispute considered as an industrial dispute, when is a dispute considered as an individual dispute. Now, when we start with industrial dispute, there are three main ingredients of an industrial dispute. One, the dispute or difference should be between the employers and other employers, or it should be between the employers and the workmen, or the dispute can be between workmen and workmen. That means it has to be between the participants of the Industrial Dispute Act. Second thing, the dispute should be connected with either the employment or the non-employment. Second, also, maybe it may be related to the terms of the employment or the conditions of labor. What are the working conditions? Third, the dispute may be in relation to any workman or workman or any other person in whom they're interested as a body, as a union. That means if a dispute is between a individual and the organization, but the union of workers supports the dispute, then it becomes an industrial dispute. This was held by Supreme Court in 1984 case of Workmen of Hindustan Lever Limited versus Hindustan Lever Limited. The Supreme Court and majority of industrial tribunals held that a dispute raised by a dismissed employee will not be treated as an industrial dispute unless it is supported by a trade union or by a body or section of workmen. Now we come to what is an individual dispute. And when can this individual dispute be declared as an industrial dispute? When there is a dispute between an individual workman employee with the organization, maybe pertaining to the working conditions or his employment or his dismissal, and if the union, the recognized the registered union supports his cause, then it can be taken as a industrial dispute. So the following conditions have to be satisfied when an individual dispute has to be declared as an industrial dispute. First is a body of workmen, that is trade union, or a considerable number of workmen are found to have made common cause with the individual workman who is in dispute with the organization. Second, that the individual dispute was taken up or sponsored by the workmen as a body, that is a trade union, or by a considerable section of them before the date of reference of the dispute to the tribunal. Summarizing this video, we spoke about the Industrial Dispute Act 1947, the object and the purpose of the act, and the difference between the individual dispute and the industrial dispute. In the next video, we will bring the important definitions under the act.